Good morning, everyone.
Morning.
Good morning.
I have several cases that are going to go pretty quickly, so I'm going to take those up, the quicker matters up first, and so I can get as many people on their way as I can, and then I'll take up the lengthier matters here in just 1 second. I did want to address the first. We have an expert, it sounds like, on Mr. Zan, Mr. Covington, on your case. I'm going to come back to the contested part with the county attorney in a little bit, because that part of the case is going to take a little bit longer. But Mr. Covington, I reviewed your file and was confused as well, and so was Judge Heppard, because we couldn't tell what you had actually set for today. And I know you've got a motion to modify, and I understand what you're trying to do. It's just you can't expect the other side to kind of read your mind. I mean, I know what you're here for, and I think Mr. Zan probably knows, what you're here for just from the history of the case, but he's not expected to have to predict that. It needs to be laid out what your hearing is for. So really what I'm going to do today is I'm going to give him time to prepare. So it sounds like what you want to do is modify the temporary orders that were previously issued by this court that dealt with supervised visitation through Guardians of Hope. And I heard you announce that at docket call, but Mr. Zan wasn't put on notice that that's exactly what you were trying to do until just now, because from the file, it's not clear that that's what you're wanting to do. So to be fair, I'm going to give them some additional time, and we're going to set this. You don't have to give any further notice. I'm going to make a docket entry that we're rescheduling this for a temporary orders hearing on a motion to modify temporary orders. So you don't need to worry about filing any more new pleadings unless you want to change what you're requesting. So we're going to reschedule this, and we're going to get a new date where everybody can come in on that date, and we can deal with the motion to modify temporary orders, because I don't find that the notice that you provided was sufficient in this case. So, and Mr. Zan, I understood your objection at docket call, and both Judge Heppard and I, as we were reviewing the cases for today, both had the same concern. So what we're going to do is I'll reschedule it. I'm going to make a docket entry, Mr. Covington, that shows exactly what we're coming back for, so everybody knows, and we'll take up your hearing at that time. But we're not going to hear the motion to modify temporary orders today. It'll probably be a couple of weeks, but I'll get you a court date here in a little bit. But I wanted to address that first so that Mr. Rodriguez could be excused and go on treating patients or whatever he needs to do.
Judge, if we could get a court date, it would save my client from having to re-subpoena Mr. Rodrigo and have him sworn to reappear,
okay.
Judge.
I didn't realize he was under subpoena, so we're going to do that. Let me get a date for y'all. So we have advanced family law. So the court is closed. It's a dead week, August 2nd through August the 6th, which is kind of when I was going to set y'all. But I can do that following Tuesday or Thursday. So I could do August the 10th or August the 12th, or I can do August the 11th. So 10th, 11th, or 12th.
Judge, the 11th works for me. I have a 1 p.m. mediation on the 10th, and I have hearings in the morning of the 12th and a mediation in the afternoon on the 12th.
Well, and since it's a motion to modify temporary orders, I'm going to put y'all on a clock, so we're not going to be spending more than half a day on it. But based on the history of this case, it seems like both sides actually present their case efficiently. So my guess is it'll probably take us an hour to an hour and a half to hear the motion to modify temporary orders. Would be my guess, but I will put some kind of time limitations on the parties. So let's do, Mr. Covington, can you do August the 11th for this hearing?
Yes, I can. Yes.
Okay. All right. This case is rescheduled for August the 11th at 9 a.m. I don't want Mr. Covington or Mr. Zan to leave, because I am going to take up the county attorney's issue on the fees here in just a second. But Mr. Rodriguez, if you would please raise your right hand to be sworn. You solemnly swear or affirm that the testimony you're going to give in this cause will be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
All right, sir, you're under subpoena, and this matter is not going forward today because of a notice issue. We're going to hear it on August the 11th at 9 a.m. So you're sworn to return to this court at that time. You're still under subpoena. Typically, I try to take expert witnesses out of order, so normally we'll try to get you in and out pretty quickly if the parties will agree to do that, so that you can get on your way. But you'll need to appear back in this court on the 11th at 9 a.m. and you'll appear by Zoom.
Judge, the same meeting ID number?
Yes, sir. You'll appear with that main meeting ID, more than likely because I have a history on the case. It's going to be sent to me, but the initial appearance will be at 9 o'clock at that Zoom ID you signed into today.
For your meeting ID or the other one, Judge?
The other one, just start
Judge
off with
Hepburn?
Judge Hepburn. Yes.
So sign in there first and then,
And then more than likely you'll be sent back to me, but just sign in with her first because
okay, okay, Judge.
never know how a day's going to play out.
Okay, thank you, Judge.
Thank you.
Judge Bell.
Well, I'm going to come back to you, Mr. Covington. Yeah.
The 20th or the 21st.
Let me take care of some of these other lawyers that are real quick, and then I'll come back to y'all and we'll address the issues that you may have.
The 21st.
I want to take the status conference up next on the adoption. Ms. Masoon and Ms. Ballou.
Yes, Your Honor.
I reviewed all the paperwork. It appears everything's in order and that it's ready to go. I think everything's good. I mean, I noticed that there was a little criminal history, but to me, it's old enough and it was just one incident. I think the gentleman was in college at the time or around the college age. And there hadn't been anything since that, 11 years ago. So to me, it's ready to go and I don't have any issues with it. I'm not sure if Judge Hepburn will hear the final hearing or me, but it's going to get approved. So there's no issues with the court.
All right, great. Thank you, Your Honor.
Thank you, Your Honor. May
Thank
we
you.
be excused?
You may. Okay. All right, on Stewart and Howard. Mr. Howard appeared yesterday. I think there was some confusion as to, and it probably is, falls in my lap. I typically write down any reset dates on my docket sheet and then give it to the coordinator and I highlight it for her to insert. But especially if I was in trial, there's a possibility that maybe I wrote down the wrong date or she wrote down the wrong date. But for some reason, we had Mr. Howard here yesterday, and so there's a little bit of confusion. But what we did initially, and Mr. Howard, I'll tell you that the first court date, I think you were served the day before the hearing date. And so Mr. Ward appeared and was kind enough to say, Judge, look, we don't want to necessarily put this gentleman in jail for not appearing at court. And we're going to give him some additional time to appear. And but it's important for you to note that if you get served with an order to appear, you can be served at 2 a.m. that says you need to be in court at 9 a.m. And that's crazy. And the court understands that's crazy, but you got to appear at court. That's a court order. And so if you don't appear at court, what happens is the judge issues an arrest warrant and you get picked up and then you get brought to court so that you understand to appear when you get served with an order to appear. So the best thing to do is when you get served with an order to appear is just appear. The court's not going to put you to trial. The court's going to give you a reset, but you've got to respect that court order and come into court on the date and the time that you're served. But I understand, and I just want you to recognize the fact that Mr. Ward could have said, Judge, I want an arrest warrant issued, and I would have issued it because technically you should have appeared. But the other thing is I want to give him time to get an attorney, Mr. Ward.
Yes,
And
sir.
I don't know that he's had sufficient time to do that. He appeared yesterday. We didn't talk about anything other than at docket call, he said, Judge, I need some additional time to get an attorney. And I said, we're not going to address that today. We'll come back when everybody's here and we'll address that issue. But I am inclined, since there's a motion for enforcement on file and a request for jail time, rather than just reading him his rights, I'd rather reset the case for, I would say 2 weeks, but I've got advanced family that next week. So you're looking at probably the earliest date I can get y'all in would be either the week of August the 9th or August the 16th. And actually August the 16th, you have a much better chance at being heard because the week of the 9th through the 13th is booked pretty heavily because we're coming off of our advanced family law seminar here in Texas, and pretty much every family court shuts down that week and goes to that conference. So the week before and the week after are pretty heavily booked. So if y'all want to do the week of the 16th, that would probably be best. Does that work for you, Mr. Ward?
Yes, Your Honor, that will work for us.
And what about you, Mr. Howard?
That should work. I am in the process of obtaining local attorney. I'm interviewing this week. So totally respect what you said. I would like to just state that I actually live in Wichita, Kansas. I was not served on this matter initially. There was confusion about that. So I just want to clear that up with the court and with Mr. Ward, that the AG office has my full information. I'm paying full support. I want to respect the jurisdiction of the court here, and our intention is to mediate this. So I do feel like I need counsel, and that time will give me enough time to get counsel.
No,
Well, and just so you both know, it's an enforcement. So the court doesn't really normally require mediation, but I would highly encourage that. So if both sides are willing to do it, Mr. Howard, and you hire a lawyer, they'll know that that's the court's philosophy, because I want to say about 88% of the cases that go to mediation end up settling. Nobody has to come to court. And then the parties are able to control their own destiny, come up with creative ways to resolve the case. Because once you come to me, I've got, it's black and white, and it's kind of, I have to follow the law. At mediation, you have a lot more options available to you that you may want to be able to, both sides may want to consider that may work better for y'all. So I would encourage y'all to mediate. I'm not going to force y'all to do that. But if for some reason Mr. Howard gets counsel and Mr. Ward, y'all need some additional time, I can tell you I'm going to be okay with that. So if for some reason y'all have a difficulty getting in to mediate, or maybe y'all want to do an informal settlement conference, but if you have trouble doing that before the court date I give you, Mr. Ward, I would be okay with one additional reset if that's what you request. After that, typically I'm wanting y'all to go. But let's look at getting a date then the week of the 16th. I can do the 16th, the 17th, the 18th, or the 19th. So any day, Monday through Thursday of that week.
1 second, Your Honor.
Is Thursday, the 19th, agreeable to the other side?
Let's see. The 19th is fine with us, Your Honor.
Okay,
What
I'm
time?
going to swear Mr. Howard to return then on the 19th here in just 1 second. Mr. Howard, when you get counsel, let them know that it's set for the 19th. That way, if they're, because we don't have your attorney's calendar with us this morning. So if your attorney has something already previously set, he can reach out to Mr. Ward and see if they can get an agreeable date. If that happens, it'll need to be somewhere around the 19th. But if that happens, Mr. Ward, the lawyers can just get Mr. Howard in on any day of the week on a Zoom call, and I'll swear him to return on the new date if for some reason his counsel can't do the 19th. But I'm going to go ahead and schedule y'all for 9 a.m. on the 19th. You'll appear at Judge Hepard's docket call, so just go back to her Zoom ID and her passcode. Mr. Howard, if you would please raise your right hand for me. The other hand. Do you solemnly swear or affirm the testimony you're going to give in this cause will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
All right, Mr. Howard, you're sworn to return to this court on August the 19th. You can put your hand down. You are going to return to this court on August the 19th, 2021 at 9 a.m. You'll appear by Zoom at Judge Hepard's docket call. You won't get any further notice from the court. You won't get served with any additional papers from Mr. Ward. So it's very important you write that date down. If you fail to appear on that date, then a capias for your arrest will issue, and you don't want that. And I understand there may have been some issues with service. I appreciate you telling me that. That's not a huge issue for the court. I just wanted you to be aware. A lot of people think, well, if they get served with an order to appear or subpoena and it's set the next day, they can just say, well, I don't really need to mess with that because I didn't get enough notice. The best thing to do and the proper thing to do is appear at court and just say, Judge, I just got served. I haven't had any time to get an attorney. But I understand you had some service issues, and we don't really need to hash that out today. All right, so the case is reset for August the 19th at 9 a.m. Anything further we need to address from either side?
No, Your Honor, we'll do a notice of hearing and send that out, file it with court and provide it to the defendant.
Okay, that's great. It's not required, but if you'd like to do that, you certainly can, because I'm going to make a docket entry that I swore him to return and I reset it for today. But that'd be great, Mr. Ward. All right, thank y'all for appearing.
Thank you, Your Honor.
Y'all have a good day. Oh, Mr. Zan, while I've got you here, we have
Yes,
a
Judge.
case. We have a case on the docket, 21-283-667, Devin Beaver and Edgar Hernandez. I show the respondent was served on June the 7th, and then he filed an answer on June the 18th. Looks like we have a temporary orders hearing set today, but I had made a docket entry that y'all need to mediate since there's no extraordinary relief requested. So I'm assuming that y'all are just trying to schedule mediation in your passing.
That's correct, Judge. It was our understanding no hearing was even set based on the docket entry.
Well, that's what we thought. That's what the judges thought too, but yeah, for some reason it was set. So thank you. I'll just mark that it's passed, and we'll get y'all in once y'all mediate.
Thank you, Judge.
Okay, let's see. All right, Miss Levert, let's get you taken care of on your cases. I guess let's deal with, which one do you want to do first? You want to do the Gonzalez matter first? Let's do that.
Yes, that's fine. Absolutely.
All right, Mr. Gonzalez, do you understand that the district clerk's office and the county has objected to your affidavit of inability to pay, saying that you can afford to pay the $300 or $310 filing fee for the divorce? And so they are objecting that you're not indigent and that the taxpayer shouldn't pay your filing fee. And so you're entitled to have a hearing on that. Typically, the court likes to have, bank records, tax returns, all that stuff for at least the last 6 months or so. But I've reviewed your affidavit and I see that you make $4,500 a month. So
No, sir. I actually was placed on a leave absence. I just lost my mother about 2 months ago. So my company gave me leave of absence. I have not worked. I'm actually trying to start up a new job that I was working. I started about 2 weeks ago.
Well, hold on just a second, because I've got to get you sworn in if we're having a hearing today. So if you want to testify and tell your side of the story, it's Ms. Levert's motion. So she's going to get to go first. And then when she's done asking questions of you or whoever she wants to call as a witness, then at that point, I'm going to turn it over to you and let you tell me anything you'd like to tell me as it relates to this matter. I can tell you that I have to decide things based on what was filed. And so if things have changed, you may need to amend paperwork and get other stuff filed so that you get your new situation in front of me. Because right now I have to go off of what is on file with the court. All right, Mr. Levert, we're going to go ahead and get started on your motion or your contest.
Can
Yes.
I get well, how much in total is the total?
I'm sorry, Mr. Gonzalez, you're cutting out on us.
Because I'm just trying to get this thing finalized. If I have to ask my aunt or uncles for money, then that's what I'll do. Because I want this done and over with. I don't want help to pay for it. I want this divorce final.
Can you hear me, Mr. Gonzalez?
Yes, sir.
Okay. Your feed is really weak, and so you're coming in kind of like a robot, and we're not getting everything that you're saying. So what I may have you do until
Let me step outside. Let me step outside real quick. That's probably what it is. Is it stronger now?
Yeah, that's better.
Okay, I stepped outside. No, what I was saying, how much was the total? Because if I have to ask relatives for help, then that's what I'll do to pay it, because I want this divorce finalized, if possible.
All right, I thought it was like 310, but the clerk just told me 398. So let me have her verify that, because
Yes, Judge, that's what I have also, $398.00.
Is that the cost for a divorce now? Or is there service fees? Because it just, it's gone up about $100 since I was practicing.
Yes, these are the court costs
Okay, so there was service.
and service.
Okay, so
Yes.
you had her
Yes, we-
served as
A
well. I see that.
constable served her. Yes, sir.
Yeah, I see that. So it's 398 because the constable charges like $85 to serve the papers. So, so you've got 398. There are a couple of issues that I have with the order, and I can go over those with you because you're entitled to a default, which means once you fix these, well, we got to deal with the filing fee. But once we deal with these issues, and I can tell you, if you're historically made 4,500 a month, that's more than a lot of the staff that's working in this court make. And so it's one of those things where I don't know what that is exactly. If you're netting 4,500 a month, I mean, that's probably 65,000 or so, close to 70,000 that you're grossing. It's going to be very hard to convince me on that income that I should have, people pay your fee. So but that being said, I'm certainly going to listen to your testimony, and I understand you may want to be starting a new venture, but and I get that, and I hope that that's successful for you. But based on what you were historically making, it's going to be difficult to convince me that you're indigent, and so because you're way above the poverty guidelines, and that's why they've objected to it. And so that being said, if you want to borrow the funds, you certainly don't have to pay it today, but you can. And you can just, because you're going to need to reschedule we're going to have to reschedule this one more time to fix this thing. So I would like for you to get a pen and paper so you can take some notes on the problems that I have so that you can fix them. That way, next time you come in, it shouldn't take us more than like 10 or 15 minutes and I'll be able to complete your divorce. But we've got to fix a few things before we do that.
Yes, sir.
You want to grab a pen and something to write on.
I'm gonna grab my other phone
All right, that's two phones.
because one's off of Wi-Fi. Yes, sir. Go ahead.
Okay. So, well, let me deal with the contest first. Are you going to get the filing fees paid before you come back next time? Or do you want me to have a full blown hearing and have her cross-examine you and all that?
I'm going to try to get it paid, because I want this done. I want this finalized already. It's been about 7 years. And
I'm going to
my ex has not been wanting to respond or anything for the past 7 years.
Yeah, I understand. And I can tell she hadn't responded once she was served. So it's more than likely next time you come in, she's still not going to have responded and we're going to be able to finish the case. But the court is going to order you to pay the filing fees based on the affidavit that's on file. And I am finding that you're not indigent based on what I've heard. So you will need to pay that. We can reschedule.
I don't have a choice. I'm going to have to if that's what I want.
Yeah, we're gonna reschedule your case. So as much time as you need, whenever you're ready and you get it paid, then you can come back in and we'll finish it up. But here, write these things down because this is what I need you to do to fix it. First, I have to have what's called an inventory. And so if you come to the courthouse and you go to the second floor, there's a law library there.
I filed all those the day that you told me. It was about a month ago. You told me to go do all that. I filed it. You said if I had enough time. You said you would try to see me that same day, but you didn't have the time.
Yeah, I did see that you filed the non-military affidavit and the certificate of last known address. So some of the things that we asked or that I told you needed to file, you did. I saw you filed everything except an inventory, but let me double check. Make sure.
Yeah, because I asked them I wrote all those things down and I asked them when I went to the law library and they gave me all the paperwork that I asked for. That you had told me to ask them for. Yes, sir.
Let me double check because I just didn't see it yesterday when I was looking, but judges make mistakes too, so let me double check. 281699. Do you see an inventory on file? Well, he said he filed it like a week ago or so, so it should already be in there. Yeah, Mr. Gonzalez, it's not showing up in the court's file. So it is possible that you filed it and it ended up in a different case. I don't know. That doesn't normally happen, but it could have happened, especially since the other stuff you filed is here. That would be really odd, but I have seen, I mean, that it's probably happened 3 times in the 6 years I've been on the bench. So I mean, the clerks are capable of making mistakes too. We have a lot of checks and balances here so that stuff doesn't happen, but occasionally papers get filed in the wrong case. So I'm not saying you didn't file the inventory. You may very well have, but it's not in my file, and I'm going to have that to finish your case. So the inventory is essentially just you list on a piece of paper, this is what you have, and this is what you think it's worth. And then this is what she has, and this is what I think the stuff that she has is worth. And I
Yeah,
know
it had to have got lost because I did fill out something like that. My spouse right now went with me and filled it out. Yeah, because I was
Okay.
telling her what to write.
Yeah, it should just be 1 page of paper normally.
Yeah.
You can ask them for the short inventory. Don't get me like the 40-page one. I don't need that big old long one. So it's a 1-page inventory, and you'll put on your column what you have and what you think it's worth, and then you'll put on her column what she has and what she thinks it's worth. And I know you're not going to know everything that she has, but just put what what she took when y'all separated or what you left when you separated, and put an approximate value on there, because since it's a default, I have to make a finding that what you have is fair and what she has is fair. So if you just list everything you have and you've got $15,000 of property, then I can't just say, well, you get to keep all that because you've got nothing on her column. So make sure you fill it out and that it kind of looks, balanced as far as who's getting what. So I need the inventory. The second thing is on your decree that you filed, you left the child support that she's going, or you left the child support blank. So we've
Yes,
got
sir, because I don't want anything. I don't want anything. She ain't been in my kids' lives for the past 7 to 8 years. I don't need anything else from her.
Okay. Well, normally I would make her pay child support based on minimum wage, but if you test, and here's the thing, because you told me earlier that you were indigent. If you have sufficient income that you can provide for the children without any help from her, and you tell me that under oath, then I'm okay waiving child support and putting no child support in there, and then you don't have to mess with it. But my opinion is both parents should help financially raise the children.
She's a threat to the family. That's the reason I left it blank. I don't want her knowing my whereabouts, my kids' whereabouts. Since the last issues, when I did give her that, we all had basically her past of family violence and all that. It's been a big issue.
All right.
And
Well,
I left it alone. I've left
Okay.
that alone. I don't want.
What we'll do is, because I only want to hear that one time, is I understand where you're going with that. And so we'll deal with that then on the day you come back. And I can tell you, if there's good reasons, and it sounds like there may very well be, then I will approve no child support, and that will be fine. And I see that the child's on government assistance as far as health insurance. The decree says you have dental insurance through your work, but is that true or is that a mistake?
I had.
Okay. So I can change that. There is, so there's a requirement in the law that in a decree, your personal information be listed and her personal information be listed. If there's a history of family violence, the court can make a finding that you don't have to disclose your personal history. So you left that blank, but based on what you're telling me, it may be that there's a reason for that. And I may agree with you, or I may say, look,
I actually put it on the very first form that I filled out to start the divorce. I put all that on that first application, I guess is what it's called. I put all that on there.
We can deal with that too then. I don't need you to change anything there. You asked for her name to be changed. We can't do that. Just so you know, I'm going to have to strike through that. She has to request a name change. You can't request it for her. So
Yes,
I
sir.
have no authority to change her name. So that part I will have to cross through. And then you left the standard possession order blank. You filed a standard possession order but left it blank. So it sounds like if there's a history of violence there, we may need to do a potentially a supervised visitation order, but I'll deal with that when you come back because it sounds like you got kind of a complicated case. And if you said she hadn't seen the kids in several
Well,
years.
Yes, sir.
Yeah. So
And I actually filed for divorce back in like 2012 or something as well. And I was fighting for full custody. So, I mean, if I have to go to child court again or family court again, then I will. Because, yeah, for those reasons. That's the reason I left.
Why is she not seeing the kids?
She is too busy being in and out of jail, and she's a drug addict.
Okay. All right. Well, then I can fix the stuff. All I really need then, it sounds like, is that inventory. Everything else I can probably fix once I hear your story. And so if you'll get that inventory in for me and then get your filing fee paid, come back in and we'll get you finished up. But you're going to finish this. You should finish this the next time you come in if you file that inventory for me.
Am I able to do like payments towards that? Do they do that? Allow that?
You can, but you've got to get it paid before you can actually, you can do a credit card if you've got a credit card, and then you can pay that off on time. They take several forms of payment, but.
No, I was just saying so that therefore I could have it paid by the time I set up another court date.
Yeah.
So therefore I can make minimal payments or something towards it, and therefore it's done before I request another court date.
Yeah, you're gonna, as soon as you get the full amount paid, the $398, then it'll be, you can set a court date. You can go ahead and set a court date if you know you're going to be able to get it paid, but you don't need to necessarily decide that in front of other people. So I'm going to let you deal with that, talk to family and what you can do. And then once you get that money ready, you'll pay that to the clerk, and they'll write a receipt up so that it shows up in my system. And you could literally come in the next day or 2 days later or whenever, and I'll get you taken care of. Okay?
Yes, sir. All right.
Thank you. And I'll sign that order, Miss Levert, on the or make a docket entry if you don't have an order. I haven't looked for the order yet. But
Yes, you should have an order, Judge. Thank you.
You're welcome. He needs to pay that. All right, and now let's go to Mr. Covington's, Ms. Levert. Mr. Covington, if you can get back on the screen for me.
I'm here, John.
Last case, we went kind of quickly, I guess. All right, so Ms. Levert, this is your contest. So Mr. Covington, if you would please raise your right hand to be sworn. Do you solemnly swear or affirm the testimony you're going to give in this cause will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, Ms. Levert, you may proceed.
Okay, thank you, Judge. I have just a small opening, nothing huge. I just want to give just a.
Sure.
Okay, thank you. As you know, we're here on a statement of inability to pay court costs. The district clerk is contesting the statement of inability to pay based on the omission of material information in the form, and that the petitioner stated that he is indigent, but he provided no proof of that. And also because what is on the form is that Mr. Covington makes well above the federal poverty guidelines. So that's why it's being contested. So right now, I would like to call Mr. Ricky Covington to the stand if I could.
Okay, you may. And Mr. Covington, you're being called as an adverse witness. What that means is Ms. Levert's going to be able to ask you questions that are leading. And so she may say, for example, Mr. Covington, you're wearing a yellow shirt. And your answer is not, no, I'm wearing a red shirt. You don't need to fix her question. You just need to answer the question, and that would be no. When you get done answering her questions, I'm going to turn the floor over to you, and you can tell me anything that you would like to tell me as it relates to this affidavit of inability to pay. So you're going to get an opportunity to explain your answers, but you'll do that when it's your time to do it. Ms. Levert, you may proceed.
Okay, thank you, Judge. Okay, Mr. Covington, could you state your full name for the record, please?
Ricky Dwayne Covington.
Okay, thank you. And now, did you file a statement of inability to afford payment of court costs on or about January 18th of 2021?
Yes.
Now, on that form, did you list any dependents? Any children who depend on you for care?
Yes, I have a 13-year-old daughter in my custody.
Okay, do you pay child support for that daughter?
Yes, I pay child support. Well, they taking it out my check, but they not getting it to nobody because she stays with me, but I'm in the process of going to court and having her officially awarded to me.
Okay. Did you go to legal aid for assistance in
No.
Okay. And do you receive any needs-based benefits, any public benefits such as food stamps, housing, Medicaid?
No, ma'am.
Okay. And now on the form, you reported that you make $2,800 in monthly wages as an assembler. Are you still working that job?
I am currently on medical leave.
Okay, you're on medical leave.
Yes. I'm currently drawing short-term disability.
Okay, and how much are you receiving per month for short-term disability?
I receive $350 a week. That's $14 a month.
Okay, and now, do you have any assets, any bank accounts?
No.
And I'm sorry, Judge, he failed to fill out the form completely, so I'm going to have to get this information through testimony.
I understand. I'm looking at his affidavit, and I can see he didn't put any assets or any of his debts down. So you may proceed.
All righty, thank you. Now, Mr. Covington, do you have any bank accounts?
No.
Do you have any vehicles?
No.
So I'm assuming you don't have a boat.
A boat?
Yes.
No.
Do you have any other property, jewelry, stocks, bonds, land?
No.
Do you rent or do you rent a home or do you own a home?
I rent.
And how much is your rent?
$800.
Pardon me?
$800.
$800?
Yes.
And how much a month do you spend on food and household supplies?
Maybe between $250 and $300.
And do you have a telephone?
Cell phone, yes.
How much do you spend on your cell phone per month?
Me and my daughter is $82 a month.
So your daughter also has a cell phone, your 13-year-old daughter?
Yes.
Okay. And how much do you spend on clothing and laundry per month?
Laundry, probably less than $100.
Okay. And do you have any medical or dental expenses?
Other than, well, right now, since I'm on short-term disability, I have no expenses, medical or dental.
Do you have any insurance you pay monthly?
As of this moment, no.
And you stated you do not have a vehicle, but how much per month do you spend on transportation, taking the bus and so forth? Uber?
Less than $100.
Okay, and you stated you pay how much in child support?
Maybe close to 1,100 a month. Little bit over 1,000.
You're paying 1,100 a month in child support currently?
Well, that's when they was taking it out. When I was working, my check would be 1,400 every 2 weeks. They would get 700. I would get 700. But that's when I was paying all three. But right now it's close. It's either over 1,100 or just under 1,100 total a month.
And
But right now, Judge, I'm not getting a paycheck, so child support isn't coming out.
do you have any other debts?
Other than stuff I put on credit, stuff like that.
Pardon?
I have no major credit card debts. I just have like debts to con and debts to furniture places, stuff like that.
Okay. Okay. Now, are you aware that your court costs are $873.00?
I wasn't, but I am now since you said so.
Okay. Now, I'm showing that you were properly served in this matter.
Yes. Yes, I
Okay.
was.
I'm sorry?
Yes, I was properly served.
Okay, so now, can you pay the $873 today?
No.
If the judge gave you a chance to pay in payments in the future, could you manage that?
When I start back work in the future, possibly, yes.
Okay, but you can't pay any of that from your unemployment check or your short-term disability check.
No, I can't.
Okay, Judge. I'm going to pass the witness.
Thank you. Mr. Zan, do you have any questions as it relates to his affidavit?
Just very briefly on the income, Your Honor, and related to the current order. Mr. Covington, you stated that you're earning $350 a week on short-term disability, which you stated is approximately $1,400 a month. That's correct?
Right.
And then you went down the line with Ms. Levert regarding your expenses each month. And you said $800 in rent. You said $250 to $300 a month for food, correct?
Correct.
So adding those two together, that's approximately $1,100 in expenses you have. And you've got a cell phone and you had laundry and you've got some additional expenses. So you're breaking even approximately with those expenses in your stated income, correct?
Correct.
However, the last 2 months, the court ordered that you be supervised through Guardians of Hope, and you've been paying that expense as well, have you not?
I've been borrowing money from my oldest daughter to pay that expense.
So you haven't been paying it, you've been borrowing money from a family member to make those payments?
Yes, that's why the time has fluctuated. First 2 times I did two hours.
Objection non-responsive after yes, Your Honor.
Sustained after yes.
Pass the witness, Judge.
All right, Mr. Covington, I have a couple of questions. This short-term disability that you're on,
Yes,
do you
sir.
have any idea how long you'll be on short-term disability? What is the outlook? For you?
The type of injury I got, the recovery time is anywhere between 6 months to a year. I've been out of work since my last day of work was March 19th. I had got my doctor to send a letter. I was supposed to go back to work this week, Monday, on the 12th, under light duty. But then my job didn't approve of it. So they called me and said that my disability been extended to August the 22nd.
And refresh my memory, I think you told me before, but is this where you got hit with like a crane or like a hook or something?
No, I didn't get, this was a non-work related injury.
Okay. And is it back related or what is it?
No, I had surgery on my knee. I ruptured my patella tendon. My patella tendon got replaced.
Okay. All right. Based on what I've heard, he brings in about 1,500 a month from short-term disability. And I'm not sure when he's going to be back working full-time. The court's going to approve the affidavit of inability to pay. Mr. Covington, when you're back at work, um, I may change this and you may be paying filing fees going forward. But as it stands right now, it sounds to me like the expenses are exceeding the income that you're bringing in. And so I'm going to approve the affidavit of inability to pay. All right, anything further and the case has been rescheduled. I need to make a docket entry on that. What date did I give you on?
August 11th.
August 11th. So
And Judge Bell,
yes, sir.
and on that case, you ordered me to do 3 or 4 visits with Guardians of Hope, and you would make your decision based on.
Well, here's what I said, Mr.
Uh-huh.
Covington, is I said, you asked me how long you have to do supervised visits. And what I
Right.
said was, you need to get at least 3 or 4 under your belt. That doesn't mean I'm changing it at 3 or 4. It's not a, hey, 3 or 4 and you're done. I
Yeah.
was just telling you, I wasn't going to hear your case until you had
Unless,
done
right.
3 or 4 visits.
Right.
So you've done, at least 4 visits with Guardians of Hope. I did tell you could come back in and we can have a hearing, but that doesn't mean changing it. I may say you're going to do Guardians of
Okay.
Hope longer, or I may say
Okay.
you're done with Guardians of
Okay.
Hope. So
Okay.
that's the fight. Is we're going to make a decision on that the next time we come in on August the 11th.
Right.
And but I want to make it clear to Ms. Reiser and to you that I haven't predetermined that.
Right.
I was just telling you, some people end up getting supervised visits and then a week later they come in and they want to modify that. Well, the court's already spoken on that issue, and I'm not going to give them a hearing because we're not just going to keep relitigating stuff. It's too expensive on the parties, and it's not efficient for the court to do that. So that's why I told you need to get at least 3 or 4 visits in before I'm going to entertain modifying that order. Okay. But if you've got those number of visits in, we will take that up. I am going to limit the parties. We're not going to do a 4-hour hearing. It's probably going to be an hour. I may give y'all an hour and a half since we have a therapist, but we'll determine that when y'all come back on the 11th. But there will be a time restriction because I don't want, as a judge, I don't want to hear things 10 times. I want to hear them normally like 2 or 3, and then I want to get the case done. So, I'm sorry, Ms. Levert, you're completed. You may sign off and
Okay.
go back to work.
All right, thank you.
You didn't hear my.
I was enjoying it, Judge. Have a good one.
You too. But so normally what we're going to do is we'll have this additional temporary orders hearing that you've asked for, Mr. Covington. And then probably what I'm going to do at that point is say, let's go ahead and get this mediated and set for final trial so that we just have one more time of coming back to court, because I don't want, and I know you don't have an attorney right now, Mr. Covington, but I've also got to be aware of the fact that Ms. Reiser does have an attorney and she's having to pay him to be present at these hearings. So I'm not going to just have multiple hearings. We're going to move this case forward. Okay. Thank you all for appearing. We'll see you back here on August the 11th. Everything will stay in place as it was previously issued under that temporary order. I know it's a cost burden on you, Mr. Covington, and that's something the court's aware of. But I also understand that that's what I wanted to do in that case, and I felt like that's what the evidence called for. So we'll come back on the 11th and decide where we go from here. Thank you all.
Thank you, Judge.
Thank you.
It's 10 o'clock.